Good morning. It's Ian Ferguson again, formerly of Mitchells Roberton Limited, now retired, and still a council member of the Scottish Law Agents Society. This is the second part of my talk on the Lands Tribunal for Scotland, an introduction, and I'd like to continue where we finished off by looking at how you make an application and looking at the stages of that as a way through what happens here. So, making an application. Once you have decided to use the tribunal, the first step is to make an application. The procedure set out on these pages broadly describes that followed by the tribunal in the majority of cases. However, due to the variety of the tribunal's jurisdictions, there are some variations. It's a helpful feature, and I can say this from practice, that once the application is in, the tribunal guides the parties through all the subsequent proceedings by making suitable orders at each stage saying what has to be done. The website states that it is generally advisable to consult a solicitor before making any application to the tribunal. Legal aid is available in appropriate cases. Legal advice at the outset is certainly worth having to ensure that you've got a sound case. I think that's the advice you give your clients. They might want to do it themselves beyond that, but they'll certainly need detailed advice at the beginning as to whether it's worth trying to make an application, do they have grounds, etc. They need to ensure there's a sound case and need to help identify the best arguments to support it. Once the clients or yourselves are confident your case or defence is well founded, the thing can proceed, and it can proceed, as I say, either by you taking it or the client might feel that they can take it further. They just can't afford you. How do you make an application to the tribunal? It's quite simple. You make the application in writing, but it's generally on a form provided by the tribunal or specified by an Act of Parliament, and you can download a suitable application form from the website. The website, by the way, is excellent. It does guide you through this procedure, and I have to say that my talk is very heavily based upon it. So I would acknowledge that it's an excellent website to give you guidance as to what to do next. Now, there is a suitable application form, as I say, can be downloaded from the website, but it is the tribunal, not yourself, who will serve a notice of the application to the respondents by sending a copy to them or to their agents, e.g. solicitors or surveyors, by recorded delivery mail. Now, in some title cases, if the benefited proprietor, who has the legal right to enforce the condition, can't be traced, the tribunal may have to place a newspaper advertisement to serve notice of the application. So it's very much like the court proceedings here, but you will be responsible for the costs incurred in respect of the notice, although the advert itself is drawn up and placed by the tribunal staff. You complete the form in as much detail as possible. You follow any guidance that's given in the form itself, and again there is some guidance there. You need to make it clear to the tribunal and to the other parties exactly what the dispute is about. So you should include copies of any relevant maps, plans, title deeds or other documents, these are known as productions, with your application. Your application must then be sent to the tribunal offices as indicated on the form. The form tells you where to send it. You must send the appropriate fee with your application in order for it to be processed by the tribunal. So, you've done that, what happens next? You've served the application, the Lands Tribunal would acknowledge the application within usually 1 week of receipt. Thereafter, the tribunal may ask for further details or clarification if the application is in any way unclear or incomplete. The tribunal then notify the details of the application to the other party or parties and invite them to give their response, i.e. their answers. The Lands Tribunal may also give notice of an application to third parties, such as neighbours, and allow them to become a party to the proceedings. Normally, the Tribunal will then ask you to give a reply to any responses received. So there will be responses coming in. The process may be repeated until the stage is reached that the application is ready to be heard. So let's look a little bit about what these responses might be. They're called answers. It's in the form of answers. When an application is intimated, the respondent is usually ordered to lodge answers within a specified period, normally 21 days, and to send a copy to the applicant, who is given the same amount of time to lodge any adjustments he may wish to make to the application in light of these answers. In most cases, the case will be sent for a hearing at this stage, but some further adjustments may be allowed if circumstances require. I think it's a good rule of thumb that if you receive answers, if you receive an application and you're involved in advising the client, I would say that the first thing you should do is have an initial go at what your answers might look like. Just use all your knowledge, all your wit to work out what might be defences, so you can sort of put together at the beginning an idea of what your answers might be to this, if indeed you're going to answer it at all. It will help you make up your mind whether there are any arguments in its favour immediately, and also give you some good prep as to what the final answers might look like later on. So it's just that I found that invaluable doing that right at the beginning, and actually what I put in as answers eventually, it was very close to what I'd done just at the outset. It just gets the mind working. As for extending time limits, etc., you can't take that as read, but the tribunal has power to extend a time limit and may do so for a variety of reasons. If it is necessary to ask the tribunal to extend the time limit, then a simple letter asking for an extension to a specific date and the reason for the request should be submitted. Now, when we say in writing, I do mean also by email. Most of it's done by email these days, as you might expect. If your request for an extension is granted, the tribunal will issue an order to that effect. Requests for cysts or continuations should also be given in writing, and an opportunity for response will usually be given. Such motions incur fees. Any hearing arising out of such motions also attract fees. So now we'll start to talk about hearings themselves, and there's a lot involved in this. Now, I've said before that I think you as conveyancers should normally be able to give the legal advice about title conditions, etc., and the effect of the Act regarding these. You'll be pretty well placed to have an idea as to what to do here, and you can consult the website, you can consult various books and authorities which will help you with that. I'll mention that later. So really you have to work out whether you're going to be doing it or not. If you're fortunate enough to be part of a larger firm, which I was, then if we had needed an application hearing, then that would have gone to a court partner to deal with rather than me. But the procedure during that initial spell is actually quite fluid, and you could be handling all other parts of it. And sometimes hearings are not required, so you might be able to do the whole thing yourself. It's friendly procedure, and please remember that. And the way the website is done and the way the tribunal treats you is very sympathetically. They want to hear what the dispute is about. They try to guide you to that, so it is entirely possible to do it. So let's talk about the hearing. Now, the hearing is when each side presents its evidence in open court and can question or challenge the other side's evidence. It's also the stage where the parties have a chance to advance arguments in support of their own positions or attacking their opponent's case. Although parties are usually entitled to have their say on the substantive issues by way of a hearing in open court, some cases might not really require this procedure. Remember that. For example, in some types of case, much will depend on the view of the members taken following a site visit. It often makes sense for the parties to agree to make submissions in writing and leave the tribunal to decide after such a visit without an actual hearing as such. Another example might be a dispute over the precise meaning or effect of a provision in an act or in a contract or title deed. The parties might agree simply to submit written notes of argument and leave it to the tribunal to decide. So again, you as conveyancers should be able to handle that. It's important to recognise that the formal application and answers are not expected to set out all the details of the parties' arguments. If it's agreed the case should be dealt with on the basis of written submissions, the tribunal will then give each side a chance to put in any written argument. That will provide an opportunity to refer to any legal textbooks, cases or other material which are being relied on in support for your submission. How soon will the case be heard? The main consideration is to give the affected parties adequate time to prepare for the hearing, and normally the tribunal will allow at least a month for this and fix a convenient date as soon as possible thereafter. The time will depend on other factors such as availability of advocates, solicitors or expert witnesses, and other cases waiting to be heard. The Land Reform Scotland Act 2003 lays down a special timetable, and cases under that Act will have priority over all other cases. Hearings are notified to the affected parties by a formal order sent by recorded delivery. You should attend the hearing, otherwise you run the risk that the case may go against you by default. Where are the hearings held? Tribunal normally holds hearings at a place that suits the affected parties. So that unlike other bodies who don't do that, they try to hold them as near as possible to the property or land in dispute, allowing the tribunals to inspect the location concerned, which is often necessary as part of the process. How about preparation for a hearing? You'll need to prepare and lodge any productions. Now, we talked about those earlier on, like maps and plans, which are very helpful for making it clear, where various properties lie, how they lie in relation to each other, and what the effect of the provision is, where it extends to, and who it might also affect. You'll need to arrange for any witnesses to attend, so if you need witnesses, then you need to do that too. Also, assist the tribunal if you provide in advance a list of witnesses that you may call, and a list of authorities to which you might refer. You'll find more about productions, witnesses and authorities on the guidance notes for hearings on the website. So, what happens at an actual hearing? At a hearing, the tribunal usually invites the applicant to take evidence from witnesses by asking them, in turn, any relevant questions relating to the matter in dispute. The witnesses may then be cross-examined, just as in a court, by the opposing party. Similarly, the opposing party or parties may lead evidence from their own witnesses, who in turn may be cross-examined by the applicant. Both parties will then be asked to present a final submission of the respective cases. Now, cross-examination is not for the faint-hearted. That's why you might want to involve a lawyer who's a court lawyer and who's familiar with attacking arguments or spotting a weakness in something that a witness has said and going for it and doing so skillfully. That is an acquired thing. So that's why I think I would always probably go for either being a court solicitor if there needs to be a hearing. Whether you're the applicant or an opposing party, it's entirely up to you whether you present your own case. I'm talking about this advice to the applicants on the website. So they have to decide whether they're going to present their own case or have a solicitor or agent do it on their behalf. If people choose to appear on their own behalf and wish to give evidence, they'll be asked into the witness box and the other party will have the opportunity to question them. You should note that except in cases where the Lands Tribunal is acting as an arbiter under a joint reference of consent, which has to be heard in private, obviously, because of the nature of the thing. So everything else is held in public, and members of the public will be entitled to stay throughout. People who are to be witnesses will very often, but not always, be kept out of the hearing until they give their evidence. The tribunal notes all evidence and submissions at the hearing and may ask questions of the parties of the witnesses and of their agents. Following the hearing, they will normally inspect the relevant locations. The tribunal can't take any further evidence at an inspection, but parties may accompany the tribunal and can draw the tribunal's attention to any matter they think appropriate. At the close of the hearing, the tribunal will usually invite parties to make submissions on the questions of expenses. Very important subject when you're talking about Lands Tribunal proceedings. While there are certain cases where the Lands Tribunal does not have the power to award expenses or legislation lays down how it's to be determined, the general position is that the tribunal has the discretion to deal with expenses, and normally, as you might expect, the losing party will be found liable to pay the expenses of the successful party. Following the hearing and any inspection, the tribunal considers all the evidence and submissions and issues its written decision on the application. The decision is usually available within a period of 8 weeks from the hearing. How do you hear about what the decision is? It's a hearing order that's given. This is a formal order fixing, a formal offer fixing the hearing gives detail of the time and place of the hearing and may give other instructions. The date will normally have been fixed after discussion, but you should tell the clerk or his staff immediately if there's any difficulty over the date or place. Unless it can be done well in advance, putting off a hearing will lead to wasted days at the tribunal office. So when fixing a time, the tribunal usually allow for some time for members' preparation and for writing, and so it's not just the hearing days which will be wasted. So you need to let people know right away if you're wanting to call off. The tribunal will not allow late postponement of a hearing without very special reason. Agreement of the parties themselves is not sufficient reason. There needs to be a good reason. The place of the hearing will be selected for convenience of the parties and the tribunal member for the parties and the tribunal members having regard to the availability of suitable venues. If your witnesses have any difficulty in getting to the place fixed for the hearing, you must advise the staff as soon as possible. Arrangement can be made to take evidence from people at or near to their own homes where there is a specific need for this, usually medical reasons. Let's have a look at the timetable. You should adhere to the timetable set out in the order. The tribunal rules provide time limits, so there are various dates that you need to follow when you're knowing that a tribunal hearing is coming up. 1. Productions you wish to present as evidence, such as correspondence, reports, or other documents, must be lodged with the tribunal at least 14 days before the hearing. Now, you have to abide by these rules. That's what they're wanting. In cases where reference is to be made to other property by way of comparison details of such properties, comparing properties against each other, these must be lodged within 28 days before the hearing. Intimation of a list of witnesses needs to be done 5 days in advance, and intimation of legal authorities, again, is 5 days in advance if possible. And remember that you have to intimate your legal authorities and these other items to the tribunal and to the other side. Where the order refers to a hearing, the intention is its meaning a full hearing at which all aspects of the case will be dealt with. Evidence and submissions will be heard by the tribunal. A decision will be given on the basis of this material and on the basis of the site visit. The purpose of the hearing is to allow you to present your case to the tribunal. You probably have set out the main points in the written application or answers. The tribunal will consider these and any written material lodged as well as evidence of witnesses, and after the hearing no further evidence or argument will be heard. So those are full hearings, but there can be debate hearings or other hearings. The whole case is usually heard at a full hearing. However, in some cases there might be an advantage in having a separate preliminary hearing to deal with any difficult legal issues, known as a debate hearing. This would make sense if the legal point was going to have a significant bearing on the type of evidence which would need to be led. In other cases, there might be a dispute about the merits of a particular application, and a separate question of compensation, which would depend on who won at first stage. If you would think it would be better to have your case dealt with in two separate stages, you should either say so in written pleadings or advise the staff of your view as soon as possible. In any event, you should read the hearing order carefully to see whether it is a general hearing or limited to a particular purpose. Everything will follow from the order that you've been sent. The debate hearing is useful. It's just like in court. There are issues, preliminary issues, which could be discussed, which might actually decide whether the case is one that should go on or not. So it's worthwhile remembering that it doesn't have to be a full hearing. There might be a debate hearing possible. Where there are disputes about procedure, the tribunal will try to deal with them on the basis of written submissions. Where it is necessary to have an oral hearing, it may be possible to have it by telephone or video conference. Sometimes a court hearing is required. Procedural hearings are usually described as such. An unqualified reference to hearing means a full hearing. What about pleadings? The hearing is not usually fixed until answers have been lodged and parties have been given a chance to make some adjustments. So it is not necessary in this guidance to say much about the pleadings. An important feature of pleadings is that written documents must give proper notice of what it is the applicant wants the tribunal to do. You need to be very clear in your purpose so the tribunal know and so the other side know what it is exactly you are trying to get. Pleadings should also give notice of what it is that you rely on to justify a finding in your favour. But pleadings are also intended to allow the tribunal and the other side to clearly identify what is in dispute. They should be used to admit and agree evidence, material which is not disputed. So pleadings are very, very helpful. Again, I don't think these are beyond your ken because they are legal points to do with conveyancing. I think you as conveyancers are ideal to do these. I don't think you need a court lawyer every time to frame it. But I think you can handle that. Evidence of witnesses. Although the tribunal is often able to put a good deal of reliance on written evidence and a site inspection, dispute issues are usually resolved by hearing the evidence of witnesses. Now, they may be necessary to explain written material. Witnesses are usually expected to appear in person and give their evidence by way of answer to questions. And cross-examination allows their evidence to be tested properly in open court. Evidence which survives such testing can be given greatest weight. And really, evidence of witnesses is helpful here to normally help your case. I do think that the selection of the witnesses has to be given a great deal of thought. Your client may not be a person who fancies giving something in court, so you may have to not call your own client as a witness. You may have to have other documents. The kind of witnesses that you can get, of course, are like expert witnesses. You might want evidence of the value of the property as it is now, and if this application were granted, what the difference in value that would make by the condition being varied or discharged. So that's the evidence of witnesses. Sometimes a party will take objection to evidence as it's being led. The tribunal will often wish to hear what a witness has to say and decide later whether the objection is legally well founded. So there can be an objection made to some of the evidence, but you're unlikely to get a decision there and then. They'll consider it later on. Some types of objections, such as whether the witness is entitled to be regarded as an independent expert, or whether the tribunal is entitled to have regard to a particular market transaction, can involve detailed factual matters and be time-consuming. Very desirable that any such issues are brought to the attention of the opponent, as well as the tribunal, prior to the hearing. This is so the issue can be resolved without impacting upon the hearing timescale. We'll have a look at some legal issues. Where the hearing is to be limited to the legal debate, the order will usually state that the party taking the legal point should submit a note of argument stating the legal propositions on which it is proposed to rely with reference to the principal authorities, the cases, and statutory provisions to be founded on. Even if the order makes no reference to this, parties should give careful thought to the possibility of providing the other side and or the tribunal with a note of their legal argument if they are not clear from the pleadings. A good argument might persuade an opponent to withdraw before the hearing. Advance intimation of legal authorities is not a substitute for making submissions at the hearing. You don't just submit the cases, you've got to pick up on the arguments and what these cases mean. The tribunal will not reach any final conclusion on legal issues until it has heard submissions. Decisions under the 2003 Act nearly always turn on the specific facts and circumstances, and reference to previous cases is seldom of assistance to the tribunal. I'd like to add to that slightly, though. The tribunal will say that, but I do think that you do need to look at similar cases because, let's face it, although the circumstances are unlikely to be exactly the same, there will be broad circumstances which will seem similar to the other one, and therefore you should be able to at least give these cases as authority. You should remember that they will be case specific, they will fact specific. They'll make their decision on the basis of the facts of your case, and that could be different from the other one, but I do think you can take general points from these other cases, and you should make reference to ones that support your position, or indeed ones that don't support your position but with which you disagree for a reason. The main benefit of reported cases is that they give a general picture of how the tribunal approaches matters. That's the point. It is helpful still to have a reference to case. This may help you decide whether to fight or settle your own dispute, but unless a case is authority for a relevant principle of law, it is unnecessary to refer to it in proceedings. Authorities should be used for guidance as to the proper approach to be taken to the law. They're of little weight if they simply show what was done in other circumstances. This is because factual decisions usually involve quite narrow weighting of factors, and little differences may tip the balance one way or the other. So, procedure at the hearing follows really fairly standard court practice. As regards expert evidence, it is expected that technical or expert witnesses will work from written documents or reports. These should normally be lodged as productions. The normal procedure is to treat the written statement as part of the evidence in chief without having it read out in full. The witness, after being put on oath, should be asked whether he adopts his statement, and he can be asked to clarify, qualify, or explain as necessary. He's then available for cross-examination and re-examination. A word about the inspection of the property. It's often necessary for the tribunal to visit the site of a dispute as an inspection. This is usually before the hearing, but is a practical approach that's to be taken to make best use of available time. Sometimes it's necessary to carry out a further inspection after the hearing. If one side attends, then the tribunal would prefer the other party to be represented too. The tribunal will often prefer to inspect unaccompanied if satisfied that it's not necessary to have anyone present to give access, or any witness to identify things about which evidence is to be or has been given. The inspection is not the place to attempt to introduce new evidence. All-important question of expenses. This is always a thing. Before you take up any case, defend a case or raise a case, the question of expenses has to be uppermost in mind. With that in mind, you should be always trying to find a settlement with the other side, so this does not have to go the full hog, and you can perhaps reach agreement if you've not previously done so. So let's talk about this. Expenses. The tribunal has power to award expenses. Two questions arise, namely who is to pay and how much to be paid. Now, the tribunal is usually concerned only with the first of these. If you have incurred significant expense in presenting your case, you may wish to ask the tribunal to make an award of expenses against your opponent. Such requests should be made at the hearing, but can be made later once the tribunal have issued its written decision. Normal rule is that the successful party will be entitled to an award of expenses against the unsuccessful party. And in straightforward cases, it may be sufficient simply to make it clear at the hearing that you expect the rule to be applied. In more complicated cases, such as cases of divided success, liability may have to be the subject of detailed written submissions once the tribunal has issued its decisions. The rule that expenses follow success is not intended as a punishment. It's a recognition that litigation costs money, and that if the losing party hadn't insisted on his or her claim or defence, the successful party would not have incurred these legal costs. Where the loser has made an offer to settle, and that offer would have given the winner much the same result as the tribunal's decision, it may be argued that the real cause of the litigation was the winner's failure to act reasonably in taking the order. There may be other examples of unreasonable conduct by the winner which would justify some modification of liability. But the rule that expenses follow success is an important principle, and the tribunal will not be easily persuaded to depart from it. Once they've decided who is to be liable to pay expenses, any dispute about how much goes to the auditor of the local sheriff court or the court of session. The auditor will act as an independent assessor, fix a proper sum in accordance with guidelines established in published tables of fees, and you can appeal his decision to the tribunal on limited grounds only. You will not usually recover every last item of expenditure you've incurred. For example, the winning side will usually be able to claim the cost of employing solicitors, and that's allowed by the regulated table of fees. This may be less than the rate you agree to pay your own solicitor. The winning side will not be able to recover the cost of employing counsel or an expert witness unless the tribunal agrees that this is appropriate. A word about the decision that's taken. The tribunal is unlikely to reach a decision at the hearing and is obliged by the formal rules to issue a written decision. That may be within a period of around 6 weeks. It depends on how busy the tribunal is and the complexity of the matter. A word about appeal. If you think the tribunal has reached the wrong decision, you can appeal to the Court of Session. In order to be successful in appeal, you'll have to show that the tribunal has gone wrong in law. A word about the preparation and submitting of forms. Although the Microsoft Word versions allow for free editing, you must attempt as much as possible to maintain the style and layout of the form. So I have to say, I just used the form, I have to say, for that. 2, how you choose to complete your application, you must, however way you do it, you must print and sign the forms and post them to the tribunal's office. The tribunal cannot accept applications submitted by email. There are a number of Lands Tribunal application forms on the website, and in my notes there are details of the various ones. For example, there's a land register referral under Section 82 of the Land Registration Scotland Act 2012 on a question relating to the accuracy of the land register or rectification of an inaccuracy, and there are forms both in the straightforward forms and Word versions. There's a land register appeal form under Section 103 of the Land Registration Scotland Act 2012 to appeal against the decision of the Keeper of the Land Register of Scotland. There's a form, one that you will probably want to have, most normal, it's to do with title conditions and application under Section 90 of the Title Conditions Scotland Act 2003 to discharge and vary a title condition, or for the determination of a question as to validity, applicability and enforceability of a title condition if it's a real burden, or a rule of a development management scheme. So that's a form that can be used for all these title condition questions. And there's a separate one under another subsection of Section 90 to renew or vary a title condition as well.